welcome to, after a long time, the 288th session of Legal Empowerment through Interaction Lecture Series. We had gone to a bit of hibernation. We are back with a topic of relevance and importance, especially because much misinformation and dissemination of things which are not intended to be or otherwise are being circulated. And end of the day, we live in a civilized society wherein to have laws to control human behavior, whether you be a doctor, a lawyer, an engineer, an architect, cannot be found fault with, because we would like to live in a structured environment wherein some sort of, like we say, my fundamental rights and rights, everything has got reasonable restrictions. If somebody is negligent, and for that matter, the definition of negligence, I'm sure that all of you would be aware, it's not any rocket science. It's just an act or omission. Whether the concerned person has acted in a manner which a reasonable and prudent person in the given circumstances would not have acted, or omitted to do something which a reasonable and prudent man in the given circumstances would have done, or something like that. I mean, it's end of the day, it's act or omission. The issue with medical profession is, unlike other professionals like a builder, a lawyer, even for that matter, or others, is that the catastrophic effect is that the person may not be there if something goes wrong, or it deals with life. So there is always a sensitive factor that also comes in. Today, we are confining our discussion to just very, very small, pigeonhole discussion. That is, we have got 3 acts. We are given the short names. I may be excused for reading out the full name. The Bharatiya Nagarik Suraksha Sanhita, the Bharatiya Nyaya Sanhita, the Bharatiya Sakshya Adhinayam. We have got the best of intelligence available on the subject by way of justices, by way of leaders of IDA, IMA, and the different stakeholders. The issue is very simple. If anybody is negligent, according to the definition of law, should we cry about the consequences? I'm sure that none of us professionals, whether lawyers, doctors, engineers, architects, chartered accountants, would say that none of us are ever negligent, or there are persons who are negligent or careless, or those who are inefficient to handle the situation or do the job about. It is just like a pressure cooker. Unless and until there are different pressure valves, the pressure build up. If the common man feels that he cannot have recourse to the legal remedies, and one by one, each one is being shut down. Lawyers now, as you know, the latest decision may not come under the Consumer Protection Act, and there is a suggestion in the judgment with saying that medical men also may not come in. Well and good. Then there is the permanent law adalat, then there is the civil law, then there is the criminal prosecution, etc. If a situation arises wherein the common man, including you and me for that matter, we also will be on the receiving end, feels that the existing system may not be sufficient, adequate, or time-bound, then we take recourse to something else. Then we see shattered windows, we see the professionals being manhandles and things like that. But if there is an assurance that there is a structured manner in which all these things can be, there is a procedure and protocol by which justice, in the sense like if somebody feels he has been wronged, can take recourse to legal remedies, is available, then to a large extent, the pressure on ground won't be there. I mean, I'm not concerned about a medical professional alone, but everybody. So I would like to start or request the eminent speakers. We are privileged with the presence of Justice V Ramkumar sir, Justice Abraham Mathew sir, and the leaders of IDA and IMA also here, who will be introduced in due course while we proceed with this discussion after we have this basic presentation. Today's primary concern is not with tortious or civil liability. We are talking about criminal culpability or liability. Jacob Mathew case. I'm sure that this audience require no introduction to what Jacob Mathew case is, wherein the Supreme Court said that you'll have to read something more into the concept of negligence as far as professionals, especially doctors, are concerned. There is a world of difference between an occupational negligence of a driver doing rash and negligent act and a doctor performing a surgery, wherein the apex court said that if ever you want to proceed against a medical man, there should be, first of all, a acceptable medical opinion, or it should a credible medical opinion, which says that in the given circumstances, the act or omission on the part of the concerned medical man is not proper, correct, and it amounts to gross medical negligence. That is something not there in the statute, for that matter. And moreover, whether an FIR could be registered, that also is answered by the Constitution bench, which went on to say that registering of FIR has got nothing to do with the what you call the offense or allegations you make. Thereafter, whatever happens, you may have different opinions. Now, today we are going to confine ourselves to the concerns that is being raised, and I just before I request Justice Abraham Mathew to address us, may I just share the statutory provision so that to keep things in perspective once again. I'm not that tech savvy. 1 second. Share that screen. Share the screen. So is it visible?
Yes.
Yeah, thank you very much. We'll just see the basic provisions. The earlier Indian Penal Code had section 32, which said words referring to acts include illegal omissions. So if somebody does a rash and negligent act, it also takes in a omission, a criminal omission on his part, except where a contrary intention appears from the context. Words which refer to acts done extend also to illegal omissions. The current BNS is 3-4. In every part of this Sanhita, except where a contrary intention appears from the context, words which refer to acts done extend also to illegal omissions. Now, let us see general exceptions. 87. Act not intended and not likely to cause death or grievous hurt done by consent. The explanation to it says about a surgeon. Nothing which is not intended to cause death or grievous hurt and which is not known by the doer to likely to cause death or grievous hurt is an offense by reason of any harm which it may cause or be intended by the doer to cause to any person above 18 years of age who has given consent, whether express or implied, to suffer that harm, or by reason of any harm which it may be known by the doer to be likely to cause to any such person who has consented to take the risk of that harm. Free informed consent, the importance is that. Now let us see the corresponding provision. 25. Act not intended and not known to be likely to cause death or grievous hurt done by consent. Almost similar thing, but still you can just go through that. Right? Now 88. Act not intended to cause death, done in good faith for person's benefit. Nothing which is not intended to cause death is an offense by reason of any harm which it may cause or be intended by doer to cause, or be known by the doer to be likely to cause to any person for whose benefit it is done in good faith, and who has given a consent, whether express or implied, to suffer that harm or take that risk or that harm, of that harm. Not much of a difference in the sessions. Now, section 89, act done in good faith for benefit of child or insane person by consent of guardian. It doesn't make any difference. 89. 92, act done in good faith for benefit of a person without consent. That's emergency situations, which is, you can say, subtle difference, but I'm sure that Mathew sir will be dealing with that. We'll come to the main concern of today's discussion. Communication made in good faith, 93, is an offense by reason of any harm. I'm telling somebody that you got a heart problem and you might die tomorrow, and he dies immediately because of some shock, is nothing. Now, 304A, causing death by negligence. Whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 2 years. The catchword is or with fine or with both. Now, let us see the corresponding provision. Causing death by negligence. Okay. 106. Whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 5 years and shall also be liable to fine. And if such act is done by a registered medical practitioner while performing medical procedure, he shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. Explanation I shall come to. Now see the distinction. Earlier, the concerned magistrate or the presiding officer had the discretion to either give imprisonment or fine. Now that discretion, it appears. I'm just presenting the issues that has been involved for the discussion for today's program. This appears that from the 106 new section, it would appear that, of course, a concession has been given. Had it been for someone else, occupational negligence, it would have been 5 years. But if it's a medical practitioner, I'm not very sure that even Justice Mathew sir or Ramkumar sir would agree with me that such a distinction ought to have been drawn, because there should be some sort of a rational nexus or intelligential differentia for having something like that. But still, it's, I mean, as of now, we got the statute. And is used. So imprisonment, once you're found negligent, is a must. And it does not just confine to medical practitioner alone. It amounts to everybody. The whoever other than medical practitioner will have to suffer 5 years and fine. But just because you are a medical practitioner, you would be excused for, or rather would need only have 2 years. For the purpose of this subsection, registered medical practitioner means a medical practitioner who possesses any medical qualification recognized under the National Medical Commission Act 2019 and whose name has been entered in the National Medical Register or a state medical register under the Act. Whoever causes death of any person by rash and negligent driving by vehicle not amounting to culpable homicide and escapes without reporting it to the police officer of a magistrate soon after the incident, whatever it is. But end of the day, two things I would like to highlight, and I hope this August Assembly would also appreciate and address, is that isn't it time that we had something like a dedicated medical law wherein instead of borrowing from X, Y, and Z statutes, we have something that is confined to a profession that deals with life and death. Let's discuss about it later. Then let us see 336. Act endangering life or personal safety. Act endangering life or personal safety. I mean, it doesn't have much of a difference, but still, we'll discuss about that also. Then you can have a look at grievous hurt and hurt, 337 and 338. though nothing is spelled out or a distinction is drawn because of the Jacob Mathew case. And for that matter, Kerala, we have some sort of privilege because even before Jacob Mathew, we had government orders and guidelines which required peer review before the police could take action against medical men. This is Jacob Mathew case. After referring to different facets, starting from Bolam and even going to Bolito, the Supreme Court held that these are the parameters on which a professional negligence has to be adduced, because the law or jurisdiction of every civilized jurisdiction understands and appreciates the fact that medicine has not been and is not an exact science. In spite of the best care, caution, and attention on the part of the treating doctor, there is always a possibility of something going wrong. And in Martin D'Souza and subsequent cases, a parallel has been drawn with the legal profession, wherein even if a lawyer loses a case, does that mean he's negligent? It cannot be, because there are factors beyond his control, because he is not the deciding factor. He can only place the facts. He can only place the pleadings and things like that. If he has entered appearance and done whatever is necessary, he cannot be found negligent. Likewise, care and not cure is what is necessary in medical profession, is an accepted legal maxim, or rather the way in which medical negligence is being adjudicated in almost all civilized jurisdictions, including India. In spite of the best care, caution, and attention on the part of the treating doctor, there is always a possibility of something going wrong is accepted. Medical science has not been and is not an exact science. Once that is accepted, does that mean that a medical practitioner or a legal practitioner can now be found fault with if he is found wanting or lacking in certain things? Then the basic definition of negligence, act or omission, come into play. With this, I'll just before I conclude my initial submissions, let us see how the Jacob Mathew concluded. Negligence is the breach of duty caused by omission to do something which a reasonable man, guided by those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. Then negligence is the breach of duty caused by omission to do something which a reasonable man. Again, fine. Now, coming back to Abraham Mathew, sir. Sir, the issue or the kind of information that is being disseminated is that the current penal statutes are inequitable and loaded against the doctors. Number one. Number two is that if that be the case, is it not loaded against every person against whom medical negligence is alleged or any sort of negligence is alleged? Even before all these statutes came into being, it was being circulated, and none of the stakeholders did seriously contest or agitate the issue that such and such requirements are there. If that be so, are we at this point of time, sir, you in the unofficial session, you were saying that there is a possibility that it ought to have, it might get a relook, etc. Over to you, sir, please.
Shyam,
Yes, sir.
Can you please stop sharing your screen?
How do I do that? Yeah, I think I can. I did that.
Okay. Okay. Good evening, sir. Good evening, Shyam. Good evening, doctors, dear friends. I think there is a misunderstanding among the doctors about the present law. There are some reasons for others to worry about the new law. But for doctors, I think there is nothing to worry, because the basic principles or the basic law under the IPC and the present BNS is the same, in the sense that the ingredients of the offense of this negligence or 106 and 304A, both are same. Basic ingredients, there is no change at all. See the definition we have already seen. Whoever causes death of any person by doing any rash or negligent act, not amounting to culpable homicide, that is the offense. There is no change in the definition of the offense. So the penal provision is the same. So I think there is no reason for the doctors to worry about in the present BNS. But what has been done is that under the 304A, the punishment was 2 years or fine. That is the same so far as doctors are concerned. But so far as others are concerned, like us or like drivers, we can take it for granted, drivers, almost all 90% of the cases under 304A are by the drivers of vehicles. So far as they are concerned, the punishment has gone up to now 5 years from 2 years. So it is for them, for the others to worry. But for the doctors, there is nothing to worry, merely because the punishment remains the same with one difference. Now, imprisonment is mandatory. Imprisonment and fine, both are mandatory. The court has no discretion. But imprisonment, there is no minimum punishment prescribed. So imprisonment can be even till the rising of the court. That means for 1 day, till the court rises in the evening, you have to stand there. So minimum punishment is not prescribed, imprisonment is not prescribed. So that means even till the rising of the court is sufficient. If the court thinks that this is a case where that is sufficient, they can impose it. So far as punishment is concerned, there is nothing to worry. But the only thing is that both are mandatory. That means imprisonment as well as fine, both are mandatory. But how much? What is the term of the imprisonment? How much? Because it is a magisterial offense even now. It's a magisterial offense. Magistrate can impose only 50,000 rupees maximum fine. So I think there is no reason for the doctors to fear that they will be proceeded against worse manner. No. But coming to this case question of negligence, the ingredients are the same even now. Even under the IPC, 3 components were there for negligence. One is a duty to take care. The second is that there is a breach of that duty. The third is that it has caused some harm to the other man, the patient. So it remains the same ingredients, negligence. But negligence, as you all know, there are 3 forums to be proceeded against a doctor. One is civil matter. The second is professional way under this act. Then the third is the criminal. These are the 3 forums under which the doctor can be proceeded against. We are mainly concerned with the criminal cases. In criminal cases, a distinction has been made by the Supreme Court that negligence, so far as the doctors are concerned, actually, mere negligence is not sufficient to attract the penal provision. A mere error in judgment, because there is a risk in every medical procedure, there may be a risk. So giving allowance for that risk involved in it, the Supreme Court has that under section 304A, or which is equivalent to section 106(1), negligence should be qualified like gross negligence. Gross negligence actually means what? Gross negligence means it should be total. That means a total negligence. Then it is a negligence of the higher degree. Negligence of a high degree is necessary. So that distinction has been given by the Supreme Court in Jacob Mathew's case. So it should be gross means it should be total or obvious. A simple lack of care or error in judgment does not attract a penal provision. Because we all know that there may be options before a doctor. what to be done in a particular case. What is the treatment to be given? There may be options. So he will take a decision. It's necessary for him to take a decision. He cannot consult the patient what to do because it is left to the doctor. So in such cases, an allowance has to be made, and even if the judgment made by the doctors, the decision taken by the doctors actually is wrong or later found to be wrong, the doctor will not be proceeded against, because that is the risk, inherent risk involved in it. But take a case where Mr. Shyam has already brought your notice the provisions in the penal code and the BNS as to consent. So the basic principle is that no person can be even touched without his consent, because every adult person of sound mind has the right to determine what shall be done to his body. So he cannot even touch a person without his consent. But you can touch a person with his consent. So the basic principles or the basic law with regard to the medical negligence is that there is no consent. That is the first one. Even if there is consent, you can do a particular lawful act. It's a lawful act. When consent is given, the procedure adopted by the doctor becomes a lawful act. But it can be done in an unlawful manner. It can be done by unlawful means also. So even if a lawful act is done in an unlawful manner, or in an unlawful, by unlawful means, then you will be guilty. So consent alone is not sufficient to attract the penal provision or to escape from the legal provision. It is necessary that you did that act, you exercise that skill with due care. Then care actually means that is contemplated by the profession. What is expected of a doctor? Two things are necessary. One, he possesses the knowledge or the skill he professes to have. Suppose a doctor says that I am a super specialist, and if he does not have that qualification, then certainly if that causes harm, then he will be negligent. Then it can be done, that skill can be exercised in a lawful manner, the manner in which he is suspected to do it. If that is not done, again, it's a case of negligence. So if in ordinary cases, suppose something goes wrong in the procedure adopted by your doctor, I think the penal provision is not attracted. So the first thing is that consent is necessary, because the medical regulation framed under the Medical Council Act, that also says that in the case of surgery, a written consent is necessary. Everybody takes consent. Even for anesthesia, consent is necessary. So I think the basic principles are the same. Then there is one question was asked whether any difference between this foreign law and Indian law. There is no difference. Actually, we have adopted these provisions from the medical book in Britain. Actually, we have borrowed it. So Bolangese, that is also from England. So the basic principles are the same all over the world, I think. Now, consent actually means, it is not mere consent. Consent means informed consent. A mere consent is not sufficient. Informed consent actually means, the Supreme Court has in various decisions have taken, what is informed consent? Informed consent is, you have to inform the patient the risk involved, the procedure you may adopt. Then you should explain to the patient the danger in not undertaking the treatment, then the uncertainties, then purposes of investigation, diagnostic procedure, options, likelihood of success for each option, the right to seek a second opinion, and the bills payable. So these should be informed to the patient before you undertake this exercise. So that is the basic law in England as well as in India also. But there are two cases where consent is not necessary. That is section 92 IPC, old one Mr. Shyam referred to. That means suppose it is detrimental to the patient. Suppose an aged man, 90 plus, he is told that he is suffering from patient. Sometimes it may be a shock to him and he may die. In such cases, you need not to tell him. You need not inform him. Instead, you can inform some others. That is the exception, one exception that is given for not taking consent. Otherwise, consent is necessary. And if you get consent for a surgery or such a treatment, that means, and if you do a thing or you discharge your duties, exercise your duties in a proper manner, I think there is nothing for you to worry about, even under the present act. Merely because the penal provision has this punishment has been changed from it is mandatory for the court to give you imprisonment as well as fine. Nothing there. But here we have to remember that. One question I have seen is that whether it will apply to this clinical doctors. It applies to everyone. So treatment actually starts from the stage of diagnosis. Not only surgery. We should not immediately jump to the conclusion that medical procedure actually means a surgery. No. Supreme Court has said that it starts from the time of investigation, diagnosis. From there. So if something goes wrong with that man because of the negligence of the doctor who conducted the investigation, he is also responsible. But the likelihood is very less actually. Hello? Hello?
You can hear, sir.
Sir, you are audible.
can
No
hear,
issues.
sir.
No issues.
Audible.
You are audible. Yeah, 100% you are audible.
So treatment actually starts with the investigation and the other parts of the till he is fully recovered. So that stage is there. Now, what is to be borne in mind that there is one principle. How can you decide it is a gross negligence or not? The question here is, in civil law, there is one principle or doctrine, or we can say some maxim is there, that is a res ipsa loquitur. Res ipsa loquitur actually means the thing speaks for itself. Then is a case of gross negligence. Nobody can acquit you. Take a case where a scissors, which happened in Calicut recently, a scissors was left inside the body of a patient. Is there any explanation for it? No explanation. So the very fact that scissors was left inside the body of the patient means he was negligent, and it was total negligence, it was obvious negligence. There cannot be any doubt. Take the other case also, which happened recently. One person went to the doctor for removing his sixth finger. Then what did the doctor do? Doctor did something in his tongue, on his tongue. Maybe the doctor must have thought that it's a tight tongue. So he did something there. Instead of removing this sixth, that means it's a clear case of negligence. The thing speaks for itself. Then take another case where this is a gauze, medical gauze. It is left inside the body of the patient. It's a clear case of negligence. Then another report decision which says that a patient was admitted with fever, and tests were conducted for typhoid. The test was negative. Still, the doctor treated him for typhoid instead of malaria. The Supreme Court held that it's a clear case of negligence. It's a gross negligence. Then take another case which was tried by me on the civil side. An ENT doctor treated a young man about 21 years, and actually he made some. He was not. We cannot say that he was not competent to treat for asthma, but it was a case of asthma, and he asked this patient to come to his hospital. I don't want to mention the place also. And he went there, and the doctor, without the help of anesthetist, administered anesthesia, and the young man died. It's a clear case of negligence. Because without the assistance of an anesthetist, he administered anesthesia. And there is another case, gynecologist, that also was tried by me on the civil side. There's a case where bleeding started. A pregnant lady, bleeding started. But the doctor who was responsible to give this consent, she did not give consent. He did not make sure that the help of an anesthetist is given. And at last, what did the woman died? So it's a clear case of negligence. So it can happen to surgeon, it can happen to surgeon, it can happen to gynecologist, it can happen to even to this clinical doctors also. It can happen to anyone. We cannot say that it is confined to surgeons. Then the word used is rashness, rash or negligence. See, the main ingredients is a rash or negligent, not rash and negligent. 106.2, there is it is wrongly used. Anyway, it is not brought into effect now. But what's the difference between a rash and negligence, or rash or negligent? What is the meaning of it? A rash actually means it is recklessness. It is recklessness. That is, you are taking the hazard, knowing fully well that it may endanger the life of the person. മലയാളത്തിൽ നമ്മൾ പറയും എന്തും വരട്ടെ എന്ന് കരുതി ചെയ്യുക. അതാണ് യഥാർത്ഥത്തിൽ recklessness എന്ന് പറയുന്നത്. That is different from negligence. Negligence, some questions I have seen, we say that why there is no mens rea. You see, actually, this is also considered a mens rea. This negligence also is actually considered a mens rea because it is a state of mind. State of mind actually means your mental condition such that you are not aware of the dangers involved in it. You are not taking care. That is also mens rea. Mens rea does not mean intention, knowingly, dishonestly, no. Negligence also is mens rea because it's a state of mind. So doctors cannot be here to say that merely because we are negligent, we should not be prosecuted. So that is one thing. That is about the present law. There is nothing to worry for the doctors because merely because the penal provision or the mandatory, it is mandatory for the court to award imprisonment as well as fine. Now a question may arise, or I have seen one question. What is the effect of the circulars issued by the government for protection of the doctors? Because investigation, it is a subject to some opinion of the expert panel, then apex body, etc., etc. The doctors shall not be immediately arrested unless necessary for investigation, etc. So what is the effect of this new law? Actually, under the General Process Act, Section 24, if a new enactment is made and there are notifications under the old Act, that will continue to be in force till a new notification is issued. But here the difficulty is that it is not actually a notification issued under a statute. It is not issued under a statute. So it is doubtful whether Section 24 of the General Process Act will apply. Even then, as the law has been laid down by the Supreme Court in Jacob Mathew's case, that is the law. It is the law of the land. Though the Supreme Court said that till government passes some orders, that will be in force. The observations or the directions of the Supreme Court will continue to be in force. And the government has issued certain directions. And assuming that that direction is no longer in force, I think IMA will certainly request the government to notify it again to avoid any confusion or the risk of somebody arguing that that's not applicable. Otherwise, the principle is the same. It is the law laid down by the Supreme Court. We cannot be easily proceeded against, and we may not take it for granted that circular is still good even under the new act. I think it is advisable for the IMA to approach the government to issue the circular again. Because
Sir, can I just interdict? The division bench of our court in 2014 1 KLT 799, that is Suvarna versus Rennie Philip. the division bench of our High Court specifically said that the circulars that are issued by the state government, as far as Kerala is concerned, has got nothing to do with Jacob Mathew, because the first circular was even prior to Jacob Mathew, and
Right.
In paragraph 20. But neither the circular dated 18/12/2006 nor the circular dated 16/6/2008 made any mention about the judgment of Apex Court in Jacob Mathew's case. Therefore,
Right.
it is not discernible from these two circulars as to whether the government has considered the directions issued by the Apex Court in Jacob Mathew's case while issuing them. So I think as far as state of Kerala is concerned, whatever be the circulars we are having right now may not be subscribing to the mandate of Jacob Mathew case.
Right. That is true. But that is the law laid down by the Supreme Court. Until a new circular is issued, under some law is made by the state government, and there is law in Kerala. So that will be enforced now. But the difficulty is that it is not a notification issued under the Act, either under the CRPC, not under the IPC or any other Act.
Correct.
Then that law is now changed. So an argument may be advanced that that is no longer good law. The circular is only executive in nature. It is not statutory in nature. So avoid that confusion. It is always better for because BNSS has come now. BNSS, CRPC, whether you can be arrested immediately or whether doctors can be proceeded against without a preliminary inquiry. These questions are there. So it is always advisable for the IMA to approach the government to issue a fresh circular, because it is not a statutory in nature. But as a principle, I think nobody will deviate from it. Everybody will go by the circular. So in that regard also, I think the doctors need not be concerned about it. They will not be arrested, because that is the judicial decision actually. It is a judicial decision. And that found recognition in the circulars also. Even though the first circular was issued before Jacob Mathew, the last one was issued after Jacob Mathew. So,
and its constitutional validity has been upheld in division bench also.
Yes, also. So I think there is nothing for the doctors to fear. The law is the same. The only difference is that it is mandatory to impose imprisonment and fine.
And that is after the finding of negligence, not otherwise.
Negligence.
We are missing the point, because if somebody is negligent, he should not be punished. Whether he be a doctor, lawyer, engineer, that may not be a fair statement, because if somebody is...
No, even this question of why the doctors have been given a privilege, a discount in punishment, that also can be raised. Suppose a taxi driver, it is his occupation, he is doing it, some negligence happens. This is his profession. So in every profession, even in the case of driving, even in the case of surgery, there are risks. Everybody takes risks. He also can say there is risk in driving, as there is a risk in surgery also. What is the difference? So I think government or the parliament has given a concession to the doctors, taking into account that it is an intellectual exercise and not a physical exercise. That may be the reason. And that appears to be a reasonable one also.
So would it be correct to say that the doctor community, whether they are dental or medical, should be more concerned about the peer committee review and the apex body, when there is no procedure at all? In the sense, like if a medical negligence comes, there is a mechanical reference by the investigating officer to the peer, the local committee headed by the DMO, etc. Yes. Nobody is being heard, and they come to some conclusion. If it is in favor of the doctors, well and good. But still the complainant can adduce fresh evidence and can request for something.
It can be referred to apex.
If it is otherwise, then only quantification or punishment is only what remains. I think we should have something, a structured thing as far as the procedure before these two committees are concerned. I don't know. I mean, I just opening up for the discussion. And before I come to Justice Ramkumar, sir, can I just ask Rajiv Jaydevan, doctor, please.
Good evening. Thank you, respected Justice Abraham Mathew, sir, for very kindly clarifying these queries and also for taking the questions in advance. And also greetings to Justice Ramkumar, sir, and also to Shyam Padman for organizing this. Whatever you have said, you described in very plain language, which even doctors could understand. So the concern from the doctor fraternity is, I believe, it is primarily about the minor change in the wording. It says it used to say imprisonment or fine. Now it says imprisonment and fine. And that has been interpreted using the word mandatory. Someone used the word, imprisonment has become mandatory if the doctor is found negligent. Now, you have kindly clarified the meaning of gross negligence, as in it is, for example, you cited some examples where prathama drishtya, that is, you can see it with your own eyes. So some other concerns, if I may, are, I believe that all of us in various professions work towards the wellness of the society at large. And we have checks and balances in place to make sure that we don't stray out of our lines of expertise. Now, when we have a legal system in place, specifically I'm talking about criminal, the criminal aspect of litigation here against doctors, we are seeing a tendency for people to claim negligent deaths for any patient who dies. See, the word negligent is being freely used on social media and media to such an extent that any patient who dies, obviously it's a very tragic event for any family. So the anger is immediately vented onto the doctor. And as doctors, we've all faced that. But I believe it is not fair that the doctor is squarely blamed for every death or nearly every death. And a vengeful family that has lost its judgment in grief could go ahead and file a case against a doctor, a criminal case against a doctor who's done everything in his or her capacity. That is the concern. And now I'm hearing from my colleagues across the country who are specialists or otherwise, they are reluctant to take sick patients. Trust me. They told me directly. They said, Rajiv, we are fearful of taking a severely ill patient. So now let's look at the flip side. Let's look at it from the grassroots level. Let's say a regular person who's about to deliver, a woman who's about to deliver is searching for a doctor or a hospital. Suppose she's a high-risk pregnancy. The doctor might say, look, we don't have the facilities. So the woman dies on the way. Person with a road traffic accident comes to a hospital. The doctor thinks that this patient may not survive. They'll say, look, I can't handle it. So because case eduthu kazhinjal apagadamana, that is, if I take the case, I may get sued on a criminal case varayunnadum. I can face a civil case varayunnadum. There's a big difference. So it is a criminal word and the imprisonment word that's really distressed the doctor community. Remember, we are not trained in law, but we respect the words you said. But these are some concerns we have as a non-legal professionals. We want good to happen to our patients, but at the same time, we want a greater good. Now, if doctors turn these patients away, doctors are afraid to treat a sick patient. I don't have to explain further what will happen to society at large. Great harm will happen. So that is the concern. Thank you.
Thank you, Raju. Can I have the comments from Ramkumar, sir, please? Sir, you'll have to unmute. Justice Ramkumar, sir, please unmute. But Raju, one issue still looms large. What will be the profession if somebody is proved and found to be negligent? Should he not face the consequences?
I agree. Yeah, there has to be, as I said, there has to be checks and balance. You can't have people stray outside a reasonable degree of competence. Of course, there's a range of what we call competence or what is acceptable. But the flip side is what
yeah, I'm sorry. Ramkumar sir, you're unmuted. Okay, Raju, please continue. I'm sorry.
I agree with what Shyam Padman said. Yes, if there's severe negligence, there has to be a process in place to make sure that it's taken care of. I'm no expert on that angle, but I'm talking about the big picture here. We can't have a panic-stricken society of doctors.
I understand. But I mean, let us also understand one thing, that may you not be so high that the law is above you, right? Because you want, you means everybody wants some sort of social security, everything. I don't want anybody to trespass into my property and things like that. If that be the case, if somebody feels he has been wronged, should he not take recourse to legal remedies? Ramkumar sir, please, your take on that.
I am joining from Dubai. I was unwell and had severe fever, etc. The cough persisted for about 3 weeks. Anyway, now today morning only you mentioned about this. I am a fish out of water in Dubai without my books and library. Anyway, I have nothing more to add than what Justice Abraham Mathew said. In fact, the crucial test for negligence is the standard of a reasonable and prudent man. Whether he be a doctor, whether he be a lawyer, whether he be a driver, whether he be a fish vendor even. The crucial test is that of a reasonable and prudent man placed in similar circumstances. What a reasonable and prudent man would have done. That is the crucial test. Once the court finds that he had crossed that, he had crossed that limit, then a finding of guilt is inevitable. So that is the crucial test. But the problem is, in reality, in fact, all the laws are made with adequate protection to all. Laws are the problem lies not in the laws, in the statutes, but in the application of the statutes. Error of, as Abraham Mathew mentioned, error of judgment is something which is known to law. Even while not acting negligently, there can be an error of law, error of judgment. Yeah, even with the best judgment, you may commit error, not knowingly or not consciously, but unforeseen, quite unforeseen. For that, there is no panacea, no solution. Therefore, in fact, we judges commit errors. That is why the trial court's judgment is overruled by the appellate court. It is further overruled by the Supreme Court, etc. We are also committing error of judgment. Only thing is, there is a protection for legal judges under the Legal Protection Act. Even there is a clause that he is protected only for bona fide acts done in good faith. If the act done is not in good faith, even a judge is not protected. Therefore, the crucial test for negligence is the standard of a reasonable and prudent man, which may change with the person we are concerned with. Then preliminary inquiry is one aspect on which there can be a protection, because the investigating officer, now fortunately the new law, I think the new law says not only confines to Lalita Kumari. Lalita Kumari deviated from the earlier judicial precedent by saying that the scope of preliminary inquiry is only to find out whether the cognizable offense is made out or not for finding out the veracity of the allegation. But now I think the new law has gone to the extent of gauging the veracity of the allegation also. So the station house officer, while conducting a preliminary inquiry, can even go to the extent of considering whether the allegation is true or false. To that extent, he can go. And 14 days, 2 weeks, the time is granted. I don't know whether it will be misused, etc. That is how whether he is police officer or any public servant, the law expects him to do properly, to do things in good faith. But if he does something in bad faith, nobody is safe. Therefore, preliminary inquiry is one such aspect. Then I don't think anything else need be stated. This is the crucial test for finding negligence, whether it is professional negligence of a medical practitioner or professional negligence of a lawyer or the negligence of any person doing a particular act. Even a person working with a tool has to be very careful. If he does it in very careless manner, causing an accident, it is a rash and negligent act. Therefore, that criterion is legally very sustainable, and you can't find any fault with that criterion. Unfortunately, while applying the criterion, courts commit mistakes. And as Mathew said, though under the new law, imprisonment and fine and imprisonment and fine has been made mandatory, that mandatory imprisonment in the absence of fixation of a minimum sentence. Unfortunately, there is no minimum mandatory sentence prescribed. Therefore, in the absence of a minimum sentence, under the CRPC section 354(4), clause 4 of section 354 allowed the court to give imprisonment till the rising of the court. I don't know about the corresponding law. There must be corresponding law also under the BNSS. Therefore, to that extent, but the thing is, will a magistrate, will a sessions judge do that? That is your concern, very legitimately raised. Given this, supposing the court is of opinion that is a borderline case, what would be the attitude of the magistrate? That is something which we can't foresee. Unforeseeable aspect. What could be the mindset of the magistrate or the sessions judge if it is a borderline case? Will he favor the doctor or will he favor the patient? And public opinion, public outcry, all will play a role, their role on the doctor. Because even though every judge is expected to be free from any such concerns, even the media, but unfortunately, media plays a very, very, I would say, pernicious role in even before the court convicts a person. Media convicts the person. Media, he is already convicted by the media. What remains is to impose the sentence. It is with such background that the court approaches the case. And if in a case where the media has already found the person guilty, a judge will think 10 times before acquitting the accused, for fear of, he may be an upright judge. And if the judge acquits the accused, even motives will be attributed. These are the concerns of judges also. Motives will be attributed. But actually, technically, he need not have any such concern. But he will feel that motives will be attributed, that somebody might have approached him or he might have acted on extraneous considerations, etc. That is why the judicial discretion, like as in the case of a discretion of the person, judicial discretion is also very important, plays an important role in the sentencing process. Otherwise, I have nothing more to add. I initially preferred to be a silent spectator because my voice is cracking. Thank you, Mr.
Thank
Shyam.
you. Thank you very much, sir.
I think the main grievance of the doctors is that there will be false allegations of negligence.
Correct.
Yes.
But there can be false allegations against the judge also. See,
False
doctors
allegations
cannot-
are there. Not
are
as
there.
here. There are false allegations. But the
That is
problem
the-
of the court
there
is
are
to
risks-
evaluate the evidence and come to a conclusion.
There are risks in every profession. In the profession of judge also, what we face allegations, but we cannot even explain. Doctors can even explain.
Sir, end of the day, we require a system wherein some sort of sanity, some sort of justice is implemented. Whether if somebody trespasses into my property, as I said earlier, or if it is an allegation against your professional conduct or misconduct, we got a set pattern. In the absence of something better, are we not supposed to go by it? Otherwise, I mean, we won't have anything. Before I come to Deepu of IDA or Dr. Jane Chimman here, I think I see our old friend Hariharan Sharma, sir, Director of Andhra Pradesh Judicial Academy. So please unmute.
We need not be apprehensive of the law. Law is well
Absolutely.
It is the application of the law.
Correct.
Even in the case of police officer, there are so many restrictions on the power to arrest. But if a particular officer has decided to arrest a person, all these restrictions will not apply. He will misuse his power. But law
Absolutely.
does not expect a person to misuse the power. Law expects a person to act in utmost good faith.
Very true, sir.
Sir,
Hariharan Sharma, sir.
Can I leave, Mr. Shyam?
Yes, sir, please, sir. Thank you for your presence, and I'm sorry that I did use all my persuasion to make sure that you are here.
You're welcome.
Thank you, sir. Sharma, sir.
Very, very humble good evening to one and all, particularly Shyam Padman sir, for sharing the invitation and providing the platform to share something. The main aspect, medical negligence and the change of the law, particularly the new laws. In that scenario, the medical negligence aspect, whether the safeguards or the challenges are going to be more or the same, is the concerns of the doctors, I believe. And from the angle of lawyers, from the angle of doctors, from the angle of judges, threefold looking is necessary. As far as the preliminary inquiry aspect is concerned, which Ramkumar sir was referring to, 173 is one thing and 223 is one thing. BNSS speaking about 173 is something parallel to 154 and 223 is something parallel to 200 of CRPC 223. So the preliminary inquiry aspect at the time of registration of FIR by the station house officer is concerned, it is between 3 years to 7 years, where the punishment is between 3 years to 7 years, the preliminary inquiry aspect, and whether preliminary inquiry is necessary or not, seeking 14-day time, taking the decision as to whether preliminary inquiry is necessary or not, DYSP has to permit and that permission is to be taken. Now the punishment scenario is, we are invited to punishment scenario being
You can't.
One second.
nice.
Yeah, please continue, sir.
Exactly. Since punishment scenario is reduced to 2 years, particularly in the context of the medical negligence with a specified thing, whether this preliminary inquiry scenario of 3 years to 7 years contemplated under 173 do apply, and it is automatic registration if it is less than 3 years. This kind of preliminary inquiry is not contemplated as far as my understanding of 173 is concerned. Now coming to the other part, if it is a private complaint, if it is a matter of reporting to police and police registering and police taking it in terms of 173, that 3 years to 7 years, okay. If it is a private complaint in terms of 200, now parallel to 223, the pre-cognizance inquiry or pre-registration inquiry and participation of accused at pre-registration stage is contemplated. Then probably in private complaint matters, there is a good scope for something to say before the matter is taken on file. That's one thing required to be considered as far as the procedural aspect is concerned. As far as the punishment aspect is concerned, minimum is which has been referred to till rising of the court, since minimum is not prescribed, and fine is mandatory. Fine component is absolutely necessary because one cannot be driven to the civil court and the Supreme Court time and again, particularly in the right of Ankil Gaikwad said that the compensation aspect need not be always to the civil court's purview, and even the criminal court can take a note of that and it can be done. And finally, the fine cap is not there, and it is restitution is what the scenario the world, entire world is moving towards, the criminal justice administration scenario towards the restitution to the original positions of the parties. The compensatory aspect can be well within the province of the criminal courts That's one thing. Then another scenario is plea bargaining is an area where there is lot of awareness, awareness or reluctance to try for plea bargaining. This is an area where plea bargaining is brought into, and some, because the minimum punishment is not prescribed, and if it is considered as a minimum punishment something, so that area could also work, particularly in the context of compensation issue can as well be settled, is one thing. If one looks in a positive attitude or positive way to use the available legal provisions, is one thought I thought of sharing with this August gathering. For the present, and lastly, the basic jurisprudential concept of negligence is concerned. It is a duty of care, and a standard of care scales are not there. The scales are to be again correlative to the context. And some medical evidence, some medical experts' evidence is annexed along with the preliminary complaint or basic complaint itself, either at 173 stage or at 223 stage. And that examination and the sufficiency of that, the expert opinion as to the medical negligence, if considered, prima facie case can as well be substantiated, and that can be the scale to examine the prima facie case, not mere the allegations, not mere the hue and cry, but the annexed and supplemented some medical record or medical evidence, a third party opinion. The neutral party opinion, neutral expert's opinion is to be the basis to come to a conclusion as to prima facie case, as far as the negligence basic in the context of medical negligence aspect is concerned. The preliminary inquiry at police stage is one thing, at private complaint stage is another thing, punishment scenario, plea bargaining. These are the areas I want to just here, or I want to throw just for move for discussion. Thank you. Eyes of you.
Thank you very much, sir. Mathew, sir, before I come to you, let us hear what Indian Dental Association to say. Deep Mathew, doctor, please.
Yeah. Yeah. Thank you. Thank you, Advocate Shyam, for the invite, and at risk of sounding insensible in such an august gathering, I must say that we've always been soft targets, and I think we're going to be even softer now after the new laws going to come. Definitely, you can say that there has been a benefit from the lawmakers by giving us maybe a 3-year cushion of not staying out of prison. But if you read along with the lines of the new laws that are being implemented, for example, the clinical establishment bill and things like this, we are being forced to become more defensive in our practice, in our daily practice. For example, in the clinical establishment bill, when you transport a patient and if something happens to the patient, it is a treating physician who is at risk. And you read it along with this line, you're looking at a 2-year term in prison if the patient, God forbid, loses his life. This, and also the other underlying factors where it definitely is going to stress out our lives and the life expectancy of doctors, definitely. And we must definitely add also to the part wherein you can foresee a situation wherein medical insurance and all those costs are going to rise because of the increased professional indemnity that is definitely going to come into play if you look at the larger picture. And I would definitely look at a larger conspiracy angle about how these things come into play, as who are behind these laws and what is that. That is my take on such situations. And we remain softer and softer. I know there are a lot of advocates here, but why doesn't the legal profession come under the consumer protection? I am setting cat the cat among the pigeons, I know, but it is something I have to say.
That's not the topic of the day,
Yeah,
but,
I know. But
that judgment has also said that in the same coin or on the same wavelength, the earlier decision of Shanda P. Nair would require a relook. It's for the medical fraternity to take up the matter before the Supreme Court and get a relook, rather.
At the end of the day, there must be a balance between the entire system, the entire ecosystem, the legal, the profession, the medical profession, the dental profession, everything. And isn't this being upset is the question here.
I understand. I mean, the differential diagnosis, whether legal, whether medical, whether dental, it has got its own. Can I just have the say of Dr. Jane Chiman, please?
Thank you, Shyam. Thank you for taking up this issue in the thick of things, actually, I should say. Main concern about doctors, I think, is because since it has become if the doctor is found negligent, he should be given both sentences. That is, he should be given jail term plus he should be given fine. That's the difference that has crept into it. That is one thing. Why has it come into being? Because IMA, National IMA, was behind this when it was first introduced. So according to the sources from National IMA, we had been given an assurance that an addition will be given, that doctors will be exempted from criminal implication. So that has not come about. But why this addition has come into? And then going by the history, if any doctor has been found guilty by criminally guilty, has he been given just a fine and he has escaped from jail imprisonment? Do you know any such cases? And another thing is, National IMA has also stated that if anything is done with not criminal intent, then the doctor should not be, that the person should not be found criminally. That is Section 26 of the new Nyaya Samhita. Will that hold preponderance over this 106A? That's the three main concern. And another concern, that is, if a doctor is found guilty, criminally guilty, his name will be permanently erased from a medical register. So he won't be able to practice at all. So if at all, if he is jailed for 1 day, as Justice has said before, till the court rises, will his name be erased from the medical council? These are the three questions that is there in the minds of doctors. Thank you.
Absolutely. I mean, I'll put it across to Abraham Mathew, sir. Before that, at least in my 30 plus years of practice, 4 or 5 doctors have been imprisoned for medical negligence. It's not that it's been always fine alone, because when it comes to, in one case, it was torsion testis and he went for conservative management or treatment. I'm not sure what that means. But the court and the experts who were examining the matter said that's pakka negligence, nothing else. I mean, whether, if at all there was any indication, you should have gone for the invasive procedure, detorsion and things like that, which you didn't. And I mean, that's one of the examples which just come to my mind right now, because I didn't tabulate all those things. Otherwise, I would have given you specific statistics. But one aspect, again, which I may reiterate, is that this provision is not for doctors alone. This provision is for negligence and punishment for negligence, with a concession given to doctors. It's not the other way around. I mean, there is no statute or there is no legal provision that has been made just to target any special provision or profession or something like that. And with these few words, I'll please request Abraham Mathew, sir, to address the queries raised by Jane Chiman, doctor, please.
I think these apprehensions of the doctors are misplaced. See, I have already brought your notice that there are 2 types of negligence: civil negligence and criminal negligence. Criminal negligence is obvious negligence, gross negligence, total negligence. And once it is found that a doctor is totally negligent, how can the profession ask that he should be acquitted or he should not be jailed? That's not fair, I think. As in any other profession.
Unless and until it is part of population control.
Then one more thing is there. Medical profession is the only profession which is entitled to certain privileges. There are many acts which give protection to doctors. Even for judges, there is only one act. But you have been given protection by several enactments now. So I think so far as the present law and the past law is concerned, they are concerned. There is no difference at all. Under section 304A, that is the old section, our judges, especially in motor vehicles cases, they used to give a flea bite punishment, flea bite sentences, just to fine, no punishment. That has been taken notice of by the parliament. That cannot happen now. That is the only thing. For doctors, once it is found that they are criminally negligent, why should we go for his protection? We should not insist on his protection. The medical profession should not insist on his protection.
Mathew said the first case that went to Supreme Court in 1964 is very interesting one, wherein a homeopath gave some sort of leaf extract for some worms. I don't know what exactly the worm it is. And that was deadly poisonous and the patient died. Bombay High Court said 302, murder, nothing else. But the Supreme Court said, no, he's holding a degree. So it is culpable homicide, not amounting to murder, so 304A.
That is true. Suppose somebody dies at the hands.
Had I done that, I would have gone into the gallows.
So that means it is a murder. But if somebody dies at the hands of a doctor.
You got a 007, license to kill.
Yes, that is MBBS means license to kill, we say sometimes. But I think as a profession, medical profession need not worry about the present law. You have all the protections you used to enjoy. Even now you have those protections. So only thing is that if a person is found criminally negligent, he will be punished.
So first thing that has to stop is this dissemination of misinformation and the way in which it has been projected. Anjolam Padichu, Ratri Raviliaki, Oka Chedo, Inati Janti Rando Luliran. Doka Padichin to Kutan Jeda. I don't know. We have the national body representative also here. We have got Dr. Srikumar, sir. Please, your concern.
Yes, thank you. Also, let me say this is a very good exercise which we have done. But my concern is this much. Let us be very frank that doctors, whenever they do, they don't have a criminal intent. This is the most important thing. They do things to save. All said and done, patients come at different levels of injury or whatever sickness. One. Number two, the facilities in each institute is different. You may not be having a scan in a rural area. You may not have a scan, or you may not have a CT scan or something like that. He has to take an immediate decision. Whereas you can't compare it with what is happening in a metro like Calicut or Cochin or something like that. But when it comes to the court of law, when you bring an expert, he says that you haven't done enough and you have not done enough, and he's convicted. Now another thing is that regarding the negligence. Okay, fine. If you have made a mistake, there is a negligence. When we talk about theory, there is a lot of things saying that we have there is a definite definition and all. But when we have seen with experience that, I think Advocate Shyam will agree with me that very often, there is a thin line differentiating between this. So if there is negligence, let it be in the form of compensation. Already the medical fraternity is in the consumer courts. We are considered as service providers, and crores of rupees or lakhs of rupees is always given awarded against the doctors. And now you have to deposit 50% of it when you go for an appeal. All this is there. And for now, if that fellow is practicing, suppose a patient has come from Assam and he goes back to Assam and then gives a case against this doctor, he has to go to Assam and fight his case. So there are such laws are already existing against the medical fraternity. Let me tell you, this is finally now, if a doctor is charged of criminal negligence, he may come out of it. Maybe he'll prove it. But the trauma which he goes through, is extreme. You can say that it was proved that he has not done any crime. But imagine the fear, all his guts to do, courage to take risk in future is gone. Not only his colleagues. And finally, such things happen, it will affect the society. It is just not merely the doctors who are going to be, it will be in the long run, if you see, doctors will not take risk, and it will affect the society. If the society has to gain from the medical fraternity, doctors will have to take risk. If this is the stage in which if doctors are going to be imprisoned, even for a single day, I am telling you, within a few years, no doctor is going to take any risk. And the society will be affected. And it should not just be IMA or the doctor community which is protesting against this. I think the entire society, including the advocates, should help us in saying that doctors can be charged of negligence. It should only be civil and not criminal, because for this reasons which I have told. Thank you so much.
Thank you, Sri Kumar, sir.
I
I
would
may
like-
not be taken amiss, but can I just say there is a basic fallacy on the premise where you presented it, because are we to believe that everybody who is a doctor is competent, capable, and can never be negligent? If that be the case, no lawyer, no architect, no engineer, nobody. Let us at least, for the sake of
error of judgment. As you said, there is something called error. So let him give criminal.
Sir,
let it be civil.
Sir, I on the lighter vein, I say that there was a time in Calicut when somebody used to say, please don't take your bike or take your vehicle outside because X is in charge of the trauma care. I don't want to name anybody. So that if ever you are unfortunate to have an accident or some sort of injury, you go to the casualty with X in charge. You might come out, I don't know in what condition. Let us at least accept that even in our profession, in every profession. If I say every lawyer is good, you say lawyers are liars, maybe. But it has to be accepted that there are incompetent, incapable,
Yes, I do agree.
negligent persons. So, if you want an omnibus fiat, are we to protect all these persons? For whom?
No, never,
At what?
never. See, there are different courts. There different avenues to give complaint. Consumer courts, civil courts, women's commission. So many the medical council. You can give complaint in all these places. He can lose
Correct,
his.
sir.
He can lose.
So your statement, sir, is that there should be complete impunity or immunity from criminal prosecution to a category who just got a medical degree. A civilized society cannot sustain
I
that.
would say that. I would say at least.
Doctor,
No,
one thing I would like to ask.
as a medical doctor, I would say yes. But if not the entire thing, at least put that or which was existing rather than telling. But what I wanted to highlight was it. In the end, it will affect the society. That is for sure.
That is a wielded threat, but still, we'll leave with it. Abraham Mathew, sir, sorry, you wanted to say something, sir.
Has the IMA any idea about the percentage of doctors convicted under Section 304A?
No, that is because of the help of advocates like Sr.Adv.Shyam.
No.
That is because the way in which the Indian judiciary, the justice dispensation machinery views this fraternity with respect, with reverence, and unless and until it is proved to such an, I'll say the term uses to the hilt, never ever I have seen a medical man convicted.
But
I would say
now, sir, the apprehension is that the situation now is going to change. Now,
no, it will not change. It will not change. See,
Dr. Samuel Koshi, sir, the apprehension is well founded in the sense like and or. But you're missing out on the point. Who is being convicted? It's not a doctor. It's a negligent person, whether he be a doctor, lawyer, engineer, or whatever he may be. Should you, can you think in a civilized society that somebody who is proved to be negligent under the criminal statute should be protected because he has got some sort of certificate with him? I don't know. It's an open platform. Your comments is most welcome. Samuel Koshi.
We are not arguing on that point. What we are saying is, in general, what is happening to the doctors' community. regarding this section, what we are discussing 304A and 106.
Correct.
I think that is apprehensive for the doctors is that till now, as Dr. Shyam has already pointed out rightly, rarest of the rarest incidences the doctors are imprisoned. The cases where doctors are imprisoned were very minimal.
Correct.
Either they were acquitted or they were given a fine. But now that fine part is going to be over. Now, if anybody is charged with a criminal negligence case, and if the court says that there is some sort of evidence of negligence on criminal negligence on his part, he has to be imprisoned, whether it is for 1 day or 2 years. So there is going to be an imprisonment. That is something. Second thing is, what is the difference between a civil negligence and a criminal negligence? We are not arguing about the negligence part. The Jacob Mathews case itself, Supreme Court 3 judges clearly said that the division between the criminal negligence and the civil negligence is very, very narrow. So it's very difficult even for the judges to say whether there is a criminal negligence on the part of the doctor or the civil negligence is there. So that part is there. So in what is happening
in
this
such case, the accused is entitled to benefits. If there is doubt, always goes to the benefit.
That's true, sir. 100% true, sir. But what
Nobody
I'm
is
saying
agreeing.
is the line is very thin. So
That
the
is true.
judgment,
But
the
when it
judgment,
is a 50-50 case, always the accused gets the benefit.
yes, sir, that is true. That is true. I'm not arguing with
Sir,
you. That is right.
will it not augur well with the medical or any fraternity that these black sheeps are exposed and punished so that the purity, the sanctity, and the respect of that profession is maintained? Or should
That's
we
true, sir. I'm not talking about one of the people who is doing the way you are saying that. There are people who are doing criminal negligence in all professions.
Yes.
What is happening in doctor society or the medical professionals is that, see, we are not dealing with ordinary people. We are not dealing with healthy people. Where people we are dealing with is sick people. Sick people who is needing help. Something like somebody has drawn into the water. So we have to help them. While helping, there can be negligence, there can be accidents. All these things can be happening. So once we do some accident in that case, that cannot be corrected. Unlike in judges' issues, these errors cannot be corrected at all. It is depending on the situation where we are treating the patient. It could be a momentary reaction from the doctor. Give this medicine, give that medicine, depending on the condition of the patient. If you see the patient after 1 hour, the situation will be entirely different. So you are assessing the patient after 1 day or 1 hour. The situation you are analyzing before one hour. So it is all different things. So unless and until we give the general independence of the doctors to act in a particular situation, as rightly pointed out by Dr. Srikumar, the sufferers will be society. Because we are also going to be patients tomorrow. So unless we have the trust in the doctor who is going to treat, we can select the doctor. Dr. Shyam has pointed out one thing. In Calicut Medical College, there is a doctor who is not reliable. You can make a complaint in the medical council, or you need not go to Calicut Medical. There are so many other options where you can rely on a particular doctor. You can go there. You can treat any type of treatment. So it's not the thing that we are talking about 1 or 2 doctors. We are talking about doctors as a society, as an entire community. So once the confidence of this society is lost or is coming down, ultimate thing is what is going to happen is there will not be any doctors who is going to take risk of risky patients like in emergency situations like. So in emergency situations is what is happening is in surgeries and emergency situations, maximum casualties happen. So now only if you check the specialty wise breakup, most of the doctors are not opting for gynecology, surgeries, this type of specialties, but the risk is high. Because they know that once in a while, they're going to practice for 30 years, maybe 1 or 2 cases is going to end their life. They are going to have it for their life. So they will be very cautious. They will not be ready to take risky cases because you can understand the things, the difficulties that they're going to go through once they are getting involved in a criminal negligence case. This is a punishment itself. Once you're getting into the criminal negligence, the harassment from the police people, the harassment from the society, the harassment from the social medias, it's innumerable casualties from the harassment. Even the family is going to be isolated. The doctor is being seen in a different entity. It's a casualty. This is a very serious issue. It's not something like you are seeing the situation like. See, the advocates are not included in the Consumer Protection Act because errors can happen in the advocates also, in the lawyers community also. But that errors can be corrected. But here the problem that we are facing is the decision taken in a particular situation cannot be corrected. And I can tell you an example. See, an ultrasound done, Dr. Shyam knows, or an ROP, retinopathy of prematurity case in 1996, where the ROP was not known to doctors at all, has been punished in 2010 or something, 2010 or 2012 or something.
Correct.
So the situation when doctors are taking a decision is entirely different from the situation when the trial is happening, and the doctors are being punished as per the situation prevailing on that day.
No, sir, I may correct you in the sense like the treatment, the modality, the procedure, the apparatus, the equipment, which was available and in vogue on the date of giving treatment alone is taken into consideration, and it will alone be taken, because nobody can in retrospect or in futuristic manner say that such and such thing can be. You were talking about ROP, correct? Premature or otherwise. The issue which a court faces is at the relevant point of time, did you have that requisite knowledge or did you use the requisite skill and nothing else? Never ever, I mean, if properly conducted and conducted in a case, will a doctor or anybody will be convicted for something which was not available or in vogue, not even not available. For example, certain things will be available in some other places, but not available in our hospitals. I never come across, and we were able to convince judges, and we have got over it also. The tide and CO2 monitor, something has to be that was not available at that point of time. Or I don't know if I spelled that equipment correctly.
I am very much thankful to the our judges who are very lenient to us till date. They are very lenient. Otherwise, many doctors would have gone behind the bars. We know. So that is a different situation. Now, what we are saying is the situations are changing, and it is going to adversely affect the doctors as well as the public itself. Because if you ask me, my son is a doctor. If you ask me, will you send him for a surgery in a surgical specialty or a gynec specialty? I will say no. Let him go for dermatology. Let him go for a lesser risky specialty. Because otherwise, once we are getting involved in a criminal negligence case, his life is spoiled. It's for years, not for days. How many advocates we are going to consult? How much of trauma we are going to go through? How
I understand, sir.
we are going to convince?
I agree also. I mean, this platform agrees, understands, but the remedy lies elsewhere. Might be, I don't know. I just giving a suggestion because it requires some sort of education in the sense like nobody is antagonistic to any particular profession. The thing is that we are not aware of the nuances. We are paranoid. You said about defensive medicine. You said that the society would be it will be detrimental to the welfare of the society. Absolutely correct. Unless and until a proper educative mechanism is there by this responsible organizations wherein the law of the country is not trying to punish anybody, but trying to maintain a system wherein errants, those persons who are not capable, incapable, or not doing it properly should be caught and punished. Otherwise, I fail to understand, sir. I mean, maybe my perception is entirely different.
This is not the right place to argue between us.
May I ask one thing? Why is it that only registered medical practitioners was included in the law?
Because at that point of time, there was no other specialty. The act was made.
No,
you are talking about registered medical practitioners.
In the BNS, in the latest.
In the BNS. Okay,
Yes.
I'm sorry.
Why there are so many other professions?
Sir, will be in a better position.
There are so many other professions that can be mentioned. Why it is only that these have been? That is my point. That is
The
our point.
Ayurveda people are going to give anesthesia and they are going to do surgeries. Government is allowing the.
No, I
you
can
need a
clarify on
bit
that.
course, you need a bit
Shyam, I
course.
can clarify on that, Shyam.
Yeah, please, James.
All doctors or all who treat are registered. Modern medical doctors are registered under non-modern medical register. Ayurveda people registered under their own register. So all are registered doctors. So doesn't mean that only modern medical doctors that come under this purview.
No, I mean, I think Dr. Deepu's concern was regarding general surgeons and then this.
No, my question is, why is it that only doctors are specifically mentioned? Why can't the other professions be mentioned? That is my question. For example, an engineer.
They are covered by the first part. They are covered by the first part. Suppose an engineer constructs a building and he was totally negligent and somebody dies because of that collapse.
100% is covered.
He will give it 5 years instead of 2 years.
See, I mean, that's because you look into the section and see.
We are given a benefit of serving less.
Absolutely. I mean, in this August Assembly, I may not be right in saying, but such a concession ought not to have been given, is my submission.
But there is one thing.
No, there again, I go back to my first
Excuse me,
thing.
I have a different take on this. See, even if it is he is imprisoned, then he is out of the medical. His registration is cancelled.
Sir, it happens to it happens to all those professional bodies or all those persons affiliated to professional bodies. There are. It's not just NMC or IMC which are having regulations. If I am contempt for something, I'm out of my BCI. If an architect, if a chartered accountant, why you just see in this single line of thought, like it happens to everybody. Let us not think that this is something that is condemning. Let the professional bodies and associations educate their members, including my fraternity, the lawyer fraternity, that these are necessary because unless and until you have in-house mechanisms, the external mechanisms will definitely step in. The in-house mechanism, if it is strong, the outside mechanisms will never, ever even peep in. The issue is that we have got that's it.
That's not, I mean, see, there should be
it is very simple.
There should be discrimination depending on the profession. See, that is what the Supreme Court in the recent judgment has said. The doctors also should be removed from the ambit of the consumer protection. That's the Supreme Court also.
Correct. I mean,
professions.
Samuel Koshi, sir, law, like any other science or social science, is an evolving one. Nothing is definite. If you say that medical science is okay, whatever you learned 20 years ago, if that's it, then there is no way medical science is going to develop. It is an evolving one, wherein the perceptions, the way in which things were viewed, changes. Change is the unchanging law of nature and any science for that matter. That is where, once they had a relook into a profession, not because judges are glorified or elevated lawyers. They didn't write that judgment just like that. It was on sound reason. That sound reason, the court said, then Shanta P. Nair requires a relook. Absolutely.
Which our senior doctor Babu Ravidan is waiting.
Yeah. I mean, he has been. Sir, you can unmute, sir, please. I saw your hand up. I just wanted to come back to you. I thought you will be a better person to have the concluding remarks. Like, sir, you'll have to unmute yourself.
I think he is not able to unmute.
I tried from my end. It's not possible. Even before I came to you, sir, I was trying to do that.
Law can give concession only to registered medical practitioners, not to quacks.
Absolutely, sir. Absolutely.
Look at Shyam, one thing.
Now the question is, who is a quack?
Yeah, just so I want to add, some sort of a statistic, like
nowadays, please.
Can you hear me?
Yeah, sure. Please go ahead.
You see, nowadays the maximum number of cases, especially the criminal cases, comes against gynecologists. And if you check the new admissions or new doctors who opts for gynecology, is coming less. Before, those who gets good rank in the merit, they used to opt for gynecology. Now most of them won't do that. Only those who get lesser rank are going to gynecology. Why? This is the reason. None of them, not even a single gynecologist, will want their patient to die. But the patient dies, All of them are going to are charged against criminal cases were charged. The thing is that they may not be convicted, but the trauma, the problems they face, especially most of them are ladies, the problems they face, it's unbearable. But that we have to keep in mind.
I fully agree with you, but the issue is gynec cases has got an emotional and some other quotient also involved. Like unlike a what do you call ortho case, wherein you do carpentry and it doesn't work out, malunion, non-union, or delayed union. Mother, child, family. The emotion is so, it's emotionally fully charged thing. If they perceive something as wrong, you cannot blame them for perceiving something because they are not learned in medical science and things like that. So what do? They can only take recourse to legal remedies. Otherwise, then and there will be some sort of what do you call breach of peace in the locality or on ground. Instead, they take recourse to legal remedies. Maybe these are all things every professional may have to face, but I fully agree with you. But does that or will that justify saying that everybody who holds this particular degree should be exonerated from criminal prosecution, or they should be confined only giving some sort of pittance to the person aggrieved in the form of compensation? Is it not asking too much?
Shyam, you give the citation of Dr. Mahathi Budwar.
Yeah. For that matter, one of my earliest cases, when I started practice way back in 1990, it was before Justice Ramkumar, sir. He was a district judge, sir, wherein continued pregnancy after DNC was the case. We had Dr. Bedhan, sir, as an expert and things like that in the matter, wherein we were able to establish that in spite of doing DNC, if there is a corneal implantation...
Salpingectomy.
Self-injectomy, yeah, correct. We were able to establish, and sir did give a verdict which was upheld by the High Court as well. It's not, what is the country we are living in? We are living in a country where there is rule of law. If there is rule of law, is legal proceedings or initiating or taking recourse to legal remedies, is it a sin? Is it something that cannot be? Then what is the other way? Quotation
Shyam, can I ask a question?
Yeah,
very
please,
quickly. Our respected judges have spent almost 2 hours for us. Very quickly, just so the rest of us understand, can you give a few quick examples of gross criminal negligence? Because there are so many of these terms, civil, criminal, gross, culpable, homicide. There are so many these clinical legal jargon. So, from your experience, so that we understand that it is not the regular doctor that will get affected by this, but it's somebody who's at the extreme end of the spectrum. That's what I understand. So can you illustrate that with some examples? You don't have to give
I can just put it like this. Negligence as such is an act or omission. But the Jacob Mathew case and thereafter, something has been added to that. It is not just mere act or omission, but it should be so gross that no reasonable doctor in the given circumstances would have done or omitted to do something.
Just give a few examples. Just give a few. But
One example I can give.
Understand.
Yeah, please,
supposing an infected eye is right eye, the surgery performed is on the left eye.
Yes. Yeah. Wrong side. Okay.
What else can be? Or for that matter, the torsion test is one, wherein almost all the standard textbook says that immediate invasive procedure, detorsion, is what is to be done. But the doctor goes for IADX and things like that on the later wing for conservative management. All these things cannot be excused.
Can I make a clarification, sir?
Please, sir, please.
Death occurs. Will this, 304A or 106 be applicable for?
Death by itself is not an offense.
Yes, what I'm asking is, suppose there is a wrong side surgery.
Sir, I didn't get you.
Suppose there is a wrong side surgery.
Yes.
Instead of left eye,
yes,
the patient is getting operated on the right eye.
Yes.
So it's a definite case of negligence.
Yes.
But will section 304A or section 106 will be applicable in that case?
304A.
304A in the new
Ration Negligent Act. The Ration Negligent Act.
Ration Negligent Act not amounting to culpable homicide.
Culpable homicide not amounting to murder.
It should result in death, not mere operation.
That's right. See, it should result in death. Then only the
Yes.
section note for
It may come under section
officer of
326.
notice will be applicable.
Samuel Koshi, sir, you should understand. Had it been someone else, it is nothing but pakka murder.
Murder.
That's true, sir. That's true. No. What I am saying is,
There should be a guilty
wrong side
mind.
surgery,
An
instead
oblique
of
motive
doing a
should be there.
right leg or right eye surgery, if you are doing a left eye surgery, it's definitely a case of negligence, but it's not a criminal negligence.
It's a criminal
Exactly.
negligence, sir.
That's not coming under 304A. It's maybe 132, 138, 139.
Yes.
Okay.
So in that case, this section is not applicable.
See, the meaning of certain words differ in ordinary parlance and in legal parlance. So in ordinary parlance, this may not be a negligence, but in legal parlance, it is a criminal negligence.
Sections will be different.
Yeah?
Sections will be different.
No, sections will be the same, but the reading of it, the understanding of it, that will be different.
So, sir, coming to the end of this, marathon session, what I would like to impress upon this August Assembly is that, number one, if at all we are feeling agreed about the new enactment law, the only thing we'll have to do is go to the bathroom, look at the mirror and blame ourselves. Because this was circulated. This was, different, like Dr. Jain Chiman was saying that assurances were given and everything was given. Fine. End of the day, we do have an act made by the legislature, which has to be obeyed, which has to be implemented, or unless and until it's varied or amended, it has to be. No other way. So at the right point of time, the right kind of objection or pressure has not been applied or not been done, we'll have to suffer it. Number two is that it is not as drastic. Of course, the ant and or requires a relook. I fully agree with whatever my statements earlier. Don't worry about that. I was just trying to incite you so that let us have a more constructive discussion. But I believe that it ought to have some sort of relook, because not that all doctors, but doctors as such try to save life. They work in trying conditions. It's only in movies where you see everybody in white and white, clean and everything. But we know the way in which the government setup and other things work, wherein you'll have to do certain acts which viewed out of context would be very, very detrimental to the person who has done it.
Dr. Shyam, are you able to hear me?
Yeah, please. Yeah. Sir, now you are audible. Wonderful. Please.
I was trying. I'm not able to unmute it.
No, sir. Now that you are being unmuted, please go ahead, sir.
Very, thank you, and congratulate you for initiating this discussion. And I'm extremely thankful to Justice Mathew, sir, for elaborating all those. But whatever it may be said, sir, doctors are very much apprehensive about this arrest and jail term. Why I say there should not be any criminal liability for doctors, sir, for 2-3 reasons. Criminal liability means whatever they do is with they are doing it with good faith, and there is no iota of any criminal intent to harm the patient. And maybe he's incompetent, maybe he is not properly trained, whatever it may be. The fact that the patient has reached to him, whatever it may be, he has no intention of harming it. Normally, doctors, if you are not able to treat it, they will refer. But regarding the torsion case also, I can say that is only an error of judgment. Had he diagnosed it as torsion of testis, but there is an option for this thing, management also. I'm not commenting about the previous cases. What I say is that when you implicate a criminal responsibility to a doctor, in the case of death, the process of death is a mystery. No control. The doctor or whoever is there, they have no control over this process of death. There have been several instances where the doctor has seen the patient or conducted every investigations, whatever it may be. But by the time the patient will be collapsing at the gate of the gate of the hospital, he will die. There is another instance, the doctor feels that the patient is very sick and he will not survive. Next day when the patient comes to the hospital, he will be surprised to see that the patient is sitting up. What he can do is to use his medical knowledge to relieve him of that then and try to prevent the death. It is not that he is committing the death. The fact is that he is not able to prevent or save the death. That is it. The doctor is not killing it. Doctor is not covered, only pushing him to the death.
Death is an unforeseen consequence.
No. Yeah, that's every disease, not a normal person. Every disease, one of the consequences of the disease is death. Maybe even a fever of 2 days duration may sometimes lead to death. There can be sudden encephalitis, whatever it may be. So the death is a process on which he has no control.
Sir, nobody has been convicted or nobody has been punished for death. But if it is proved by independent medical evidence given by the medical fraternity and the standard textbooks available that death was on account of some act or omission, which is gross in nature, then and then alone, the doctor or the medical man is found negligent. It's not that...
Shyam, even then I say, the punishment is not the imprisonment only. Charge him with enough this thing, monetary policy. Let him have it. Severe punishment.
If you can afford to pay money, you can be negligent.
Yeah, whether he is able to afford or whatever it may be.
It is more or less like what I said earlier, 007. That is the James Bond thing. So you have the money, you go around killing person. Not that.
No. Even if he's not having money, even if he's not having money, punish him with that, because
I'll put another equation. I'm a policeman. During the discharge of my duties, I exceed my authority, beat up somebody, kill somebody. I should not be punished criminally, only compensation.
No, that is different. That's a normal person. I am treating an abnormal person. He is a normal person. I am treating an abnormal patient. The milieu is different. I don't know the consequence. And death is one of the complications, one of the process of
okay, I agree with you, sir. I mean, just for a final
the only problem is I could not prevent death. I could not save him from that. That's all. I am not pushing him to death. The cause is having a disease. One of the complications, one of the processes that I am not able to prevent that. That's all.
Sir, as a senior doctor with so much of practice and vast experience, can you keep your hand to your heart and say that you are not seen a doctor who did something which no doctor with common sense would have done, which resulted in death? Where you would have thought that this person should never have been given this medical degree.
Then the problem is that if that is so, we would not have such an impression. It goes through so many people, no? An over-enthusiastic police person. And an advocate having grudge against a doctor. I have seen so many, pardon me, because even so many interdepartmental, even the retired judges, they have narrated me that he had bad experience with the doctors, So there will be a prejudiced mind, possibility is there. And when you are interfering in a person, where the death is one of the consequences of the individual which he is carrying, and he could not prevent death, how can you implicate that criminal liability to him? If that is so, the society has the responsibility to give confidence to the patient, the doctor. Sir, you go ahead. Even if he is dying, we will give you precaution. Otherwise, which doctor will be attempting an emergency cases? Now in America, there are no doctors opting for gynecology. So what do they? The patient will have to run for hours, kilometers to find a gynecologist. Now, majority of the doctors' children are not willing to opt to the medical profession. They don't want the medical profession. They are seeing the worry of the doctors. The society should give confidence to the doctors to face the emergency and try to save. They can say, they may not be able to say 100%, but they will be able to say 1 or 2 patients. You are now pushing the doctor to identify the patient, not touching the patient in case of emergency, being sympathetic to him, and you refer the patient to some other places. On the way, the patient dies. Nobody has complaints. But suppose you treat the patient, give an injection, and the patient dies, the doctor is at fault. So what will be as every person has an instinct to save himself, no? Suppose Shyam is in that position, what will you do? You will just keep quiet and say, you go to Connecticut. Why should I take this responsibility? If the society around you, if the parents, if the relatives say, doctor, you go ahead, the consequence we will face. So he will have confidence. Now the doctor will feel that, so the not ending judgment. What if a surgeon does a surgery thinking that the sword is kept above his head? He will be thinking about the cause of his rather than
that is the judgment that is being followed.
I am not telling. The negligent doctor has to be punished, and he has to be isolated. Remove his degree. You take away his degree. And the process of criminology trying from the police level to the court are not correct. If that is so, a case awarded by a lower court, how the other court is correcting it? If they are 100% correct, that decision should be correct to the next stage also. So a lower court is giving a complaint or a punishment. Why the superior court is removing that? That means the court also can err. So here, a doctor is dealing with a mechanism, the consequence of which, one of the consequences is death. And nobody knows who will die at which period and what. And you should give confidence to doctor to face the situation. If the society is not doing that, naturally the instinct of the patient, they will evade from that, and the society is the final sufferer. If you categorically says that the doctor should be punishment, natural instinct of the doctor community will be to save himself, not save the patient. So what he will do, he will be safe. So he will leave the rest to the fate of the patient. He will he will say that it is very serious, kindly take him to Calicut. On the way, the patient will die. Nobody has complained because they say the doctor has said it is serious. But had he attempted to treat the patient, at least 1 or 2 patients should have been survived. So give confidence to the doctors to face the situation. If you want the doctors to be punished and not giving confidence to the patient doctors, natural instinct of doctors, keep away from the problem and let the patient face their own situation.
I fully agree with you, sir. I mean, for that matter, let the society leave doctors to face the consequences. And we know what's happening around. We need an orderly society. We need protection.
Mathew, I don't remember the exact section in the general exceptions of IPC. I think it is 92 or 89 or so, where a surgeon performs a surgery in utmost good faith. 89. Yes. At most good faith. But due to some unforeseen circumstance, patient dies. Nothing. Section starts by saying nothing is an offense.
Right.
It is not an offense.
I mean, what is necessary is education of the relevant provisions of the Act and not just magnification of a minuscule area wherein some sort of punishment is to be meted out to negligent persons. Person may include doctors because the section is not confined to doctors. Doctors are given concessions.
Remove him from the registry. That is the punishment.
No,
you
sir.
remove him from the medical registry.
If I do a crime and it's only removal from registry,
he will not be able to practice. That is enough. That is more than enough.
What happens?
That will be a professional death.
What happens if his appeal is ultimately allowed?
Correct. Let us
that is a different process.
Let us have a word or two from Shankar Mahadevan, please.
Shyamji, thank you for organizing this, and thank you, Abraham Mathew, sir. I just have a query that whether for the truck drivers, whether the same law is kept under abeyance now, because I heard so.
Yes, it is kept under abeyance. Yes, it is
Why?
kept under abeyance.
Why?
I didn't get you. Abraham Mathew, sir, I didn't get that.
That is
The nation was a 5 years.
That is with regard to not reporting and the 10 years punishment where he has escaped after causing the
Okay,
accident.
okay, okay.
And
That is 106(2). Hit and run.
106(2) alone.
106(2).
Hit and run.
That has not been notified.
That has got nothing to do with our discussion.
That is uncontextual. This is not totally uncontextual. That is a different.
It's, I mean, that's the issue. I mean,
transport
we concentrate on issues which are non-issues. We magnify issues and we interpret in such a manner depending upon our political, social, cultural, or whatever colors we want. It has got nothing to do with the issue that we are discussing. Even the social media, I found, certain things were forwarded to me wherein it was said X, Y, and Z things. I mean, let us educate ourselves as responsible citizens, as responsible individuals. Forget that I belong to a fraternity. Doctors, we are all Indian citizens. You have a law for the country. It has come around as per the due process. We were all part and parcel of it. If we had objected, and end of the day, who's making the law? Our own representatives. Our own representatives whom we elect, and they go there and furtherance of our interest, laws are being made. So whether we like it or not, let us suffer the loss, number one. Number two is it requires interpretation. It requires some sort of clarification. Which till Jacob Mathew, we never thought that these provisions could be read down in such a manner, wherein a word that is not there in the statute could be added. Abraham Mathew, sir, please correct me. It was never there in the statute. It is something that has been 100%. So,
Jacob Mathew, this particular word was added, clause, by interpretation. By interpretation, that too, for a particular professionals or community. So, I mean, the legal system of the country is always over anxious, not to protect doctors, but to protect the health and welfare of the community, for which the requisite protection and requisite confidence has to be given to all the stakeholders, including doctors. But, sir, please. So, Ramkumar sir, you were saying something, I'm sorry.
No, I didn't.
Okay. So what I understand from the discussion is that doctors are afraid of the risks involved in this profession.
Correct.
See, the principle of the law is that the more the risk, the more the care one should take. That is the law actually. And you have to pay a price for being a member of the medical profession. We judges also pay a price for being a judge. We have to face these allegations. You also have to face the allegations. That is the price you pay for being a member of the medical profession.
Sir, we are concerned. We are all afraid, not only concerned, afraid, and we are really afraid and concerned. Sir, one logic. What is the logic in keeping advocates away from the Consumer Protection Act,
Sir,
including doctors in the? If the law is perfect, lawmaking machinery is perfect.
Sir,
What is the logic? I could not understand. What is the logic? But I am not initiating a discussion on that.
No, that's what I said. Please read that judgment. If you want, I can share it on screen right now.
I know that divisional bench has recommended for review. And
that apart. It is not sound reasoning. It is not just because advocates, they cannot be touched. Nothing like that. Consumer Protection Act, there are certain definitions. Who is a consumer? What is deficiency in service?
What is the job? What is the difference in the job of a doctor and
absolutely not? Absolutely
no difference. No difference.
I would
say
no
difference. A doctor doing to his client and an advocate doing his client. What is the difference?
That's what I said.
No difference.
Absolutely no difference.
Who creates the definition? Who creates the definition?
In view,
Shyam, who makes the definition?
The definition is made by the legislatures, sir. You and me, fools going and voting for X, Y, and Z. These persons do it. The court only interprets. The law is made by your representative, my representative. Let us own up. At least let us be man enough to own up that the laws are made by our representatives.
Advocate Shyam, I beg to differ with you on that matter.
Please.
When there were 3 new laws that were coming up, even the IMA and IDA, we all sent representations on those laws. Not even a comma was changed. So what happens to the
Doctor, I will tell you one thing. The persons who drafted this bill, they were totally incompetent. The new laws are actually, it's a comedy of errors. The police and the trial courts will have to face the difficulties.
Sir, actually, I'm not talking about this law. I'm talking about, there are other laws. For example, the National Medical Commission law, the National Dental Commission law, the Clinical Establishment Act, all these. We have sent multiple representations pointing out errors in the construction of those acts. There was absolutely nothing.
Right.
You are not sufficient a pressure group to prevail.
Sir, I am a citizen of India, sir.
Yeah, correct. So, I mean, now that we have had a discussion on this aspect, it wasn't for coming to any conclusion or a definitive, what you call, opinion, but to understand the nuances, to understand where do we stand. Let us stop the dissemination of misinformation. And with these words, may I request Dr. Rajiv Jayadevan to render the concluding remarks. If Abraham Mathew sir has got anything more to say, please.
No, nothing more.
Ramkumar sir?
Nothing, absolutely nothing.
Okay.
In fact,
Rajiv.
I don't find any flaw in the law as such, only in the application of the law by the stakeholders at every stage, whether the police, or by the
agree.
police or the judiciary or whatever it be. It is the application of the law which is where the problem lies.
Correct.
Sir, all the stakeholders will have to be educated because the importance of this profession has to be instilled to all the stakeholders. The justice dispensation machinery should be made aware that the health is of primary concern, and the doctors should also be aware that they are to act reasonably, sensibly, and with competence. Otherwise, don't wait for the association to remove you from the roles. You've got some other work to do. Rajiv, all to you.
Yes, thank you. I know I'll be brief. I know it's late. Our respected Justices, Abraham Mathew sir and Justice Ramkumar sir and other respected legal experts who are with us, and special thanks to Shyampadman ji and all respected doctors who are here. I'll just summarize this with just a metaphor. We all agree there is a disease, but there is disagreement about the treatment. So doctors are arguing that the treatment that is prescribed now might be worse than the disease itself. So I think that's what I see. So I think that is the way I'll summarize the discussion. It's not about disagreeing. It's not about right or wrong. It's about we make certain corrective measures to fix certain problems, but that may actually unearth a larger problem, is what I and many other doctors have pointed out. So we agree that it needs a relook, and I greatly appreciate the very patient listening and the clear communication, because I thought I'll never understand the legal terminology, but all the experts who spoke here spoke so clearly and very patiently, and we greatly appreciate your time. You put this together at short notice, and it was very well attended. I think we were having around 160 attendants, people waiting to get in. Obviously, we, as from the medical fraternity and from IDA's side, we are very, very grateful, and thank you so much.
Thank you very much.
Thank you.
It has been a nice exercise, and I hope everybody carries the underlying message.
Excellent.
So, till we meet again next time.
Thank you.
Take care.
Good night all.
Good night.
Good night to all. Good night to all.